good morning. Thank you for joining us on the fifth in our series of Brexit Brunch webinars. The fifth one with Global Mobility, hosted by Emma Brooksbank, Partner of Immigration, and Alex Angelides from Associate in Tax. If you've got any questions for any of the panelists, please use the Q&A function at the bottom of your screens. If you've got any technical issues throughout, please use the chat function and I can answer these. I'll hand you over to Emma. Thanks very much.
Brilliant. Thanks, Tom. Good morning, everyone. So in terms of the structure of today's session, I'll be speaking for about 15 minutes on employment of European nationals. I'll be touching on the new immigration system, then hand over to my colleague, Alex, who will look at the tax implications of global mobility. And then it'll be back to me for 15 minutes or so at the end. And then we should be left with some time right at the end to answer some of your questions. Any that we don't get to answer, we'll be following up with, so don't worry if your particular question doesn't get answered, but we'll do our very best to get through as many as we possibly can at the end of the session. So if we move straight on now to look at right to work for European nationals. So when we're thinking about right to work, we have to think about this just in the context of where we are in terms of the Brexit process. So we've come to the end of the transition period. That was on the 31st of December 2020. And we're now in this grace period, which takes us through till the 30th of June. It does put us in a slightly unusual position because we won't see any change to right to work provisions and requirements until the end of the grace period, and so until the 1st of July. So it is a case of sort of watching this space, keeping an eye out for new guidance coming in readiness for 1st of July. And of course, we will be publishing updates in terms of changes to guidance. But from your point of view as an employer, what do you need to know now if you're going to employ a European national? Well, you just need to know that a European passport or ID card is sufficient. You don't need to worry about when a person entered the UK, whether they entered before the end of transition or during this grace period. You can still accept passport or ID card. Now, there won't be any changes to right to work checks applied retrospectively. So if you are employing anybody during this period and you've completed a compliant right to work check, that will be sufficient, and you don't necessarily need to be concerned about undertaking a further check. So if we move on to the next slide now, please. Thank you. Now, some employers, lots of employers, will be concerned about the fact that a person who arrives from Europe for the first time after the 1st of January and onwards will actually need a visa to work lawfully. People who were here before need to apply on the settlement scheme, and most people will have applied. Settlement scheme gives them their permission to stay, so they're limited or they're indefinite leave to remain. But if they've arrived after the 1st of January, they need to proactively secure permission, so leave to remain, which gives them permission to undertake the job that they are considering undertaking. Now, that does mean that as an employer, because you're not required to ask for evidence of that visa, you might end up with people who are working without permission to do so, and that may well be inadvertent on both sides without any sort of deliberate illegal working situation. And the Home Office does recognise that employers might want the reassurance of knowing that their workforce is working legally and lawfully, and as such, you can ask for people to provide proof of either their visa status or registration on the settlement scheme. But because that's not lawfully required under right to work guidance, you can't mandate that. So you can't say it's a condition of your employment that you provide us with this proof. But what you can say is, could you provide us with this proof on a voluntary basis? But you must be careful to do that in a non-discriminatory manner. So that would mean, for instance, not identifying people on the basis of nationality, and any communication that goes out in these terms should go out to the entire workforce so that there's no concern about potential discriminatory practices. So if we move on to the next slide now. Brilliant, thank you. Now, you might be thinking, well, hang on a second, everything I've ever known about right to work is that we have to check every single person before employment, otherwise we'll get a civil penalty and we end up paying, you know, £20,000 to the Home Office for each legal worker. So what's going to happen if I have people deliberately or inadvertently working illegally within my workforce because I've employed them during this grace period and I haven't checked whether they have their visa? Well, because you will have completed a compliant right to work check by having sight of a passport or ID card, you are not at risk of incurring a civil penalty if it later transpires that that person in fact does not have the right to work. But there are risks, and those risks are around business disruption and reputational damage. So most employers would not wish to have people within the workforce who don't have the required status, because potentially if it later transpires that they don't have the right to work, you would need to terminate their employment. That will cause a problem for you as an employer, but also there's a sort of relationship of trust there, and no doubt you would want to protect your employees from inadvertently falling into a situation where potentially they are overstayers, and they may have been overstayers for quite some time. So as such, it's anticipated that you will be asking for evidence of status, or that you will be providing communication about the requirement to have status, and then allowing people the opportunity to make their own inquiries in terms of what they need to do if they don't have the status that they require. So if we move on to the next slide now, I'm going to now just look at the headlines of the new immigration system. So you've probably heard that the immigration system has changed. The rollout was so headlined as a new points-based system. The reality is that it is just a restructuring and an amendment to the old system. We had a points-based system previously, and much of the architecture of that system has remained the same. So we still need to hold a license in order to be able to employ somebody from overseas. We have to issue a certificate to them, and they use that certificate in order to evidence their sponsorship under the system. Now, the big change is that this system applies equally to European nationals as it does to people from the rest of the world. So there's absolutely no differentiation, there's no preferential treatment anymore for European nationals. Now, it doesn't, of course, apply to people, European nationals, who are resident prior to the 31st of December, because they will fall into the settlement scheme. So they won't need, and you won't need, to worry about the broader immigration system for those people. But anybody new that you're looking to recruit, you will be looking to the immigration system to do that. So if we move on now, we'll just look at a few of the key changes. So we've seen the skill threshold reduce from graduate level down to what's called RQF level 3. So that's about A-level level. Now, what does that mean? That means that many more occupations fall within the immigration system. The Home Office gives us a list, and that list used to just include graduate occupations, but now it's a lot longer because it includes these mid-level occupations. So the system has broadened out. Now, in recognition of that reduction in skill requirement, there's also been a reduction in the salary requirement. We used to look at 30,000, now we're looking at 25,600, and that goes down to 20,480 in certain circumstances. For example, if you're recruiting somebody into a shortage occupation, or if somebody is what's called a new entrant into the role. Now, we also have a difference in salary at the indefinite leave to remain point. So this is where a person has been sponsored by you or by you and a combination of other employers for a period of 5 years. They will qualify for indefinite leave to remain. And we used to have to get our salary thresholds up to 35,800, which is quite challenging in some sectors, and would certainly be challenging where we're looking at these A-level roles. Now, that has gone. We don't need to worry about 35,800 25,800. What we need to look at the indefinite leave to remain stage is 25,600. And importantly, with all of these salary thresholds, the figures that I've mentioned are what's called baseline. So that's the minimum salary threshold. But we also have to pay the going rate for the role, and the Home Office in that list that I referred to, they tell us what they consider to be the going rate. So we have to pay the higher of baseline and or the going rate. Now, there's no longer a cap on visas, so you can essentially recruit into any role as long as it meets the skill and salary threshold, and you can recruit as many people as you have genuine vacancies to fill. And the other key headline is that the resident labour market test, which if you've been involved in sponsorship previously, you'll be familiar with the very, very prescriptive requirements to advertise a post to the resident labour market, and that if you had a suitable person from the UK or Europe at the time, you would have had to have preferred them over somebody who might have been a better candidate but who was from overseas. So you had to prioritise the resident labour market. Now that has gone completely. So not only does that mean that the process is more straightforward and streamlined because you're not having to do advertising in a prescribed manner for a prescribed period of time, it also means that you can genuinely recruit the person who you consider to be the best person for the role without needing to think about where they're from. So whether they're from India or France or the UK, if they're the best person for the role, you can put them into that role, provided you've satisfied the requirements under the sponsorship system. So it's just as a final point before I hand over to my colleague, I've just said, you know, the system is now more straightforward, it's more streamlined, it's faster, it's easier for employers to deal with compared to the old system, but it is definitely no compensation for free movement. So free movement has gone, and we will need to be embracing the immigration system, and that does require quite a bit of specialist knowledge and some good, robust HR systems in place. So I'll come back to you after Alex's session, but I'm going to hand over now to my colleague Alex, who is a tax specialist, and he'll be running through some of the implications from a tax and national insurance perspective of this sort of global mobility field that we're now operating in. So I'll hand over to you, Alex.
Thank you, Emma. Good morning, everyone. So I'm going to try and go over the usual tax issues that UK businesses face when they employ international employees. So I think we need to first understand what the basics are so that we can identify the issues. So I'll start with UK income tax. So generally speaking, UK tax residents pay UK income tax on their worldwide income. So in order to determine whether someone is a UK tax resident, there are three types of tests. So you've got your automatic overseas tests, automatic UK tests, and what's called the sufficient ties tests. They're quite lengthy, so I'm not going to go over them in much detail, but I'm going to just quickly go through the main subtests. So starting with the automatic overseas tests. Generally speaking, if you're in the UK for less than 16 days in a tax year, you will not be UK tax resident. And that applies if you have been UK tax resident in one of the last 3 tax years. If an employee hasn't been UK tax resident before, if they spend less than 46 days in the UK, they will automatically not be UK tax resident. The main automatic UK test is the 183 days test. So if someone spends more than 183 days in a tax year in the UK, they will automatically be UK tax resident. The third type of test is a bit more complex. It works on what's called a tie basis. So for example, if you've got accommodation in the UK, you'll have an accommodation tie. If you've got a family in the UK, you've got a family tie. And depending on what ties you have, there's a number of days that you can spend in the UK before you can before you will become UK tax resident. One thing to note on that is that because of coronavirus, as you all know, there have been people stranded in other countries. So HMRC do recognize that. So up to 60 days can be disregarded from any test. But that will depend on the facts, and it's only given in exceptional circumstances. You know, so if someone is, I don't know, like locked down in their own country and can't leave, you know, isolating or something. So these are the three types of tests. From an employer's point of view, what most businesses find useful is having a set of guidelines for their employees so that they know what the situation is, especially now, because you will find that, you know, if you've got internationally mobile employees, they might decide to, you know, work from their own country, sometimes without even telling their employer. So I think a set of guidelines as a practical point is quite important. So moving on now to the situation where someone is not UK tax resident, they will only have to pay UK income tax if they perform duties in the UK, unless those duties are merely incidental. So from those two tests, you may have noticed that you might have a situation where an employee might have to pay double tax. So if we imagine a French national, for example, subject to French tax, if they perform UK duties, they might also be subject to UK income tax. So usually, with a lot of countries, the UK has a network of double taxation treaties. So these may operate to make sure that an employee isn't subject to a tax on the same income. However, that's not always the case, and there are huge administrative requirements to make that work. So I think what you will find is that most employers prefer their employees to just be UK tax resident, and they will issue guidelines to that effect. So I think that's enough for income tax for now. So if we move on to national insurance contributions. So generally, again, NICs are due where the work is done. However, the treatment depends on the territories involved. Before Brexit, there was some exceptions for EU countries, and that continues to be the case now. So the UK has entered into a UK-EU trade and cooperation agreement, and that now governs the position with NICs and EEA countries. So under the new agreement, I think the most notable thing that carried through Brexit is short-term assignments. So if you're an international group, for example, and you send one of your employees to another country, you have the option, the employee has the option to continue paying UK income tax, subject to certain conditions, and subject to obtaining a certificate from HMRC. The same applies for EU employees coming to work in the UK, but similarly, they need a certificate from their own tax authority. Now, the certificate isn't the only requirement. So you'll need, to continue having a direct relationship with that employee. And there are several other factors, but that's something to bear in mind, that there's a process to follow before you can do that, before you can elect to continue paying national insurance in your home country. With non-UK countries, I'm afraid the answer is, sorry, non-UK. With non-EU countries, the answer is it depends. The UK has what's called reciprocal agreements with several other countries, and similar exceptions may apply. However, for each jurisdiction, you'll have to review the facts in its case. So could we move on to the next slide? So in terms of risk from an employer's perspective. So one thing that came out of the coronavirus crisis is that a lot of employers now have to ask themselves, do we actually have a taxable presence in another country? So if you imagine my example earlier of an employee deciding to work from their home country without telling anyone, what needs to be considered is whether that creates an obligation in that other jurisdiction for the business to account for employment taxes. So again, going back to the point that employees need to understand what the implications are of just deciding to work from abroad. Another risk that isn't always considered is what's called, it's a risk of creating what's called a permanent establishment in another jurisdiction. So if that happens, one of the implications are that the business might need to pay foreign tax in that jurisdiction. So for example, if a UK company has a foreign subsidiary, usually that foreign subsidiary might be subject to foreign corporation tax, but that might also be the case if there's a permanent establishment. And the risk with internationally mobile employees is that if an employee acts as what's called a dependent agent in another country, that in itself might create that permanent establishment. So this is someone who, for example, can bind the company or make orders to business. So that's something to consider. And going on to the practical implications, all these rules that I mentioned about permanent establishment, having the risk of having to be responsible for taxes in other jurisdictions, they're not always going to be based on UK law. They're more likely to be based on foreign law. So you probably need to consider getting local tax advice where appropriate. In terms of national insurance contributions, if you do have people going on short-term assignments or coming from abroad on short-term assignments, consider whether you need a certificate from the relevant tax authority. Generally speaking, as I've mentioned before, just know where your employees are working from, especially now, because it's so hard to keep track now that everyone is working from home. And the last point that I've got on my slides is, again, the permanent establishment point. So know what your employees are doing in other jurisdictions, because that might create additional tax obligations, not just for employment taxes, but for the business as well, if they create a permanent establishment. So these are the basics. So I'm going to leave it to that. And I'm just going to hand over to Emma again to talk about frontier workers, I believe.
Brilliant. Thanks so much, Alex. Yeah, so frontier workers, I just always think it's worth highlighting this. It's an interesting little category that's been introduced. Now, we didn't need this previously because we had free movement, but you might find that you do have people in this situation. And so I think it's worth me just highlighting this to you. Now, frontier worker, it's quite straightforward. They live in Europe and they work in the UK. But interestingly, they could be working or self-employed in the UK. And even more interestingly, they don't have to have been doing a significant amount of work in the UK in order to qualify as a frontier worker. However, they do have to have been undertaking this activity as a frontier worker before the end of transition. So it's a bit of a one-hit wonder, as in we won't be having no new frontier workers will be created if they were not undertaking activity in the UK prior to the 31st of December 2020. But it could be a good, helpful scheme, for instance, for people who do very short-term periods of work. I've recently been speaking to a group of event venue companies, and they, for example, have people who come over just to work for a certain event for a few weeks in the year. Now, those people are working for a UK entity for those few weeks, but are resident in Europe, and they would fall into this frontier worker category. So it's quite helpful for them. Now, if we just move on to the next slide, you'll see that there's a very straightforward application for a person to make if they are a frontier worker. The application is free, and they'll be granted a permit for a period of 5 years, and they can extend that for as long as they remain a frontier worker. So it gives them a good straightforward access route to the UK to enable them to continue working in the pattern that they have become accustomed to. Now, at the moment, they don't strictly need a frontier worker permit to enter the UK because we're still in the grace period, but they will need one once we reach the end of the grace period, and that end point is fast approaching, so it'd be well worth people applying now in readiness for the 1st of July when they will need their frontier worker permit to enter. So that's all I'm going to say on frontier workers. So I'm going to just move on now and think about business travel. Now, I know that there's been a question, I think, that's come in from you. Thank you, Linda, about business travel. So I hope I'll be able to answer that question within the content that I'll cover now. So we had the Brexit deal that came through on Christmas Eve, and of course there was very, very little immigration provision in there in terms of providing or access to the UK labour market for European nationals or to the European labour market for UK nationals. And the reason for that was really that the UK had already stepped away from anything that looked or felt like free movement, and had already decided that European nationals would be subject to our full immigration system. They did, however, agree that there would be limited provisions for business visitors, and these are really modelled on what we call the Schengen arrangement. So Schengen is a group of countries that includes most of the European countries and a couple of non-European countries, and that area provides for border free travel between those countries. But these provisions are within the deal, but they're just modelled on the Schengen arrangements. And essentially they allow for visits, business visits, for up to 90 days within a 180-day period. They do also include visits for tourism purposes, short-term medical treatment, and the visit of family and friends. And I think, Linda, your question was, well, if I've been in Europe for 90 days for business purposes, does that mean that I couldn't then enter as a tourist? And I think it does mean that. I think that you could only have 90 days in 180 days for a combination of those purposes. So whether it's a business visit or tourism or visiting family and friends. But you could, of course, wait until the 180-day period expired, and then you'd have a new 180-day period during which you'd have a new allowance, as it were, of 90 days. Now, business activities include all the things that you might imagine. So visiting suppliers, attending meetings, delivering training, going to consultations, negotiating and entering into agreements, visiting clients, engaging in commercial transactions. So it will cover most of the activity that you might anticipate as a business visitor. But it is important to remember that if we're thinking about this going from the UK to Europe direction, that person will be employed by the UK entity and will be going to Europe, but only for a visit. So it wouldn't catch somebody, or it wouldn't provide for somebody who would be undertaking work in Europe and being paid for that work directly by a client or by a European entity. They should be paid and therefore employed by the UK entity at all times. Now, that's not to say that people can't work in Europe, but it's just a much more complicated jigsaw puzzle at the moment. So if we're looking to spend over 90 days in 180 days, or if we're looking to work in Europe, then we need now to have an understanding of the provisions in each one of the countries that we're going to. And now that sounds probably horrendously complicated, but actually over time we'll start to build up a stronger picture, because there are some countries, lots of countries, which have made provision, for instance, for people to have short-term paid engagement in Europe, but it's just that we don't have a one consistent approach. So we have to understand what the domestic provisions are in the country that we're going to, and if we're going to several countries and undertaking paid work in several countries, then we'll need to understand the provisions in each of those countries. Now, the European Commission has produced a spreadsheet, and when you look at the spreadsheet initially, you can kind of see the enormity of the problem, because it's it's 6 sheets and has no end of footnotes, and has some provisions which are just in the national language of the country that's provided those. But as I say, there are provisions in there from lots of the European countries, and over time we will build up our knowledge as to how those pieces fit together. But of course, because this is domestic legislation, it could change at any point. So you would, if you're in that position, need to get up-to-date advice and make sure that you had a good understanding of the domestic provisions in the country in which you're going to. Now, historically, European countries have been much more relaxed than the UK, for example, about immigration, certainly on a short-term basis, even for work on a short-term basis. So it may be that a person doesn't bump up against issues, but that's not to say that they don't need to investigate the requirements thoroughly, because if they did end up having breach, inadvertent or otherwise, it could then impact their future ability to potentially work in Europe, but more importantly to work in other countries where perhaps there is a more tightly controlled immigration system. So the message really is that if we're falling outside these kind of broad business activities, then we need advice on the provisions for each separate country, and we need that advice at the time that we're proposing to travel. Okay, I think that probably covers it. Yeah. So I hope that was helpful. I hope it gave you a really good overview of some of the issues around global mobility and working in the UK for Europeans, and a little touch on working in Europe for UK nationals. I'm going to hand back to Tom now. I can see that we've had lots of questions coming through as Alex and I have been talking. So Tom will take us through for the next actually about 20 minutes looking at some of those questions. And as I said at the beginning, if any do remain unanswered, we will be picking up on all of those personally, and we'll also be sharing a recording of this session and the slides, and the recording of the session is also posted on Freeths' LinkedIn page. So if any colleagues didn't get a chance to attend, they'll be able to view it from there. So I'll hand back to Tom now. Thank you.
Perfect. Thanks very much, Emma and Alex. So the first question for Alex: if an employee of a UK company is non-UK tax resident and works from another country, what are the tax implications for the UK employer?
Okay, so if they're not a UK tax resident, they would only be subject to UK income tax to the extent that they perform duties in the UK. So if they never come into the UK, then there shouldn't be any UK income tax. However, from an employer's point of view, it will be important to obtain local tax advice, because you'll need to see whether them working there creates an obligation for the employer to either account for tax or be responsible for the payment of tax in whatever jurisdiction that is.
Okay, perfect. I think a follow-on from that is, what if the employee in question is a director and only occasionally comes to the UK for board meetings, for example?
Right. Okay. Well, so we did. So as I mentioned in earlier during my presentation, there is an exception for merely incidental activities. So if they come to the UK to perform just incidental activities, however, HMRC do not consider attending board meetings as incidental. So that would create a liability, and in that scenario, you would usually need to do an apportionment between the payments to the employee, that is.
Perfect. Thank you. One for Emma. Our organisation hasn't yet decided whether or not to apply to be a sponsor. As we don't really have any shortages of applicants to vacancies, can you advise on our wording to overseas applicants who have seen our advert and have asked if they can apply and whether we are a sponsor? We don't want to respond in any way that is discriminatory or against equalities, but equally don't want to waste the person's time.
Yeah, it's a good question. I think that the best approach is to deal with this head on, and perhaps within the body of the advert, because as you recognise, you don't want to waste people's time. So within the body of the advert, you could say something that's fairly uncontroversial and accurate along the lines of we are not currently in a position to offer sponsorship for employment visa purposes. That is correct. You're not in a position, you don't have a sponsor's license. And if it goes into the body of the advert, then that message is being sent to everybody, and so wouldn't fall into a risk of discriminatory practices.
Perfect, thank you. Another one from me. As an employer, would it be appropriate to send out communication to all staff in the UK to request proof of right to work from the 1st of July?
Yeah, it is appropriate, and there's been recent Home Office guidance. It was issued last week that does recognise that employers will wish to reassure themselves that their workforce has lawful permission to work for them. The thing, though, that you would have to recognise, and it would be very important that anybody within the company who was dealing with this was aware of it, was that if a person, say, refuses for whatever reason to provide you with additional proof of their right to work, and if they had provided proof that was required by guidance at the time they were employed, so just to put that into context, if they were employed, say, in February this year during the grace period, the guidance required they provided their European passport, and they did provide their European passport, then yes, in July, you could ask everybody who was recruited during that period on a voluntary basis to provide evidence of their ongoing right to work, but you couldn't make their ongoing employment conditional upon receipt of that right to work. You would have, I mean, it would be unusual for somebody to refuse, but you would have to bear that risk and be willing to bear the risk, knowing that there isn't actually a risk of an illegal working penalty. The risk is just later down the line, potential business disruption. So yeah, you just need to be very aware of the voluntary basis of a requirement, and be aware of what the guidance said at the time that that person was employed.
Perfect, thank you. One for Alex. What duration would a short-term assignment be classed as, both EU to UK and UK to EU?
In terms of duration, it's 2 years.
Perfect, thank you. One for Emma. Should we be asking all recruits what date they entered the UK, i.e. before or after the 1st of January? What is the best approach?
Yeah. So no, there isn't a requirement at the moment, because you're not needing to understand what visa regime they fall into in order to complete a compliant right to work check. And then in the future, we will need to have a look at what right to work guidance says. And that guidance guidance will be issued in readiness for the 1st of July, but the likelihood is that that guidance will say you need to have sight, for example, of a valid passport, for instance, together with a visa which permits them to do the work in question, and it may specify that that visa or that permission, that leave to remain, might be on the online system, so it might be digital status, or it might be the more traditional system of having a biometric residence permit. But as an employer, you're not necessarily going to need to determine whether somebody was a pre-Brexit resident or a post-Brexit resident, because you will be asking them for their evidence of permission to work, and they will be providing you with that evidence, and that evidence will be whatever was required based on when they came to the UK. And it's important to remember that whether somebody comes and has an entitlement to register on the EU settlement scheme, or whether they arrive after 1st of January and they need a visa, what they're actually obtaining is the same thing. They're obtaining leave to remain, so permission to stay. It's just the mechanism by which they obtain that leave to remain. So as an employer, you would be asking them for evidence of their leave to remain, and they would provide that in whatever form they'd been given it, and you would just need to check it against the right to work guidance at the time.
Thank you. Hopefully a positive answer to this question. Will changes to the immigration system make overseas recruitment more viable option for us in the future?
Yeah, absolutely, absolutely. I mean, you know, we can't dress it up as being uncomplicated. It is still complicated, but you know, some of these changes are really positive, I think. So you know, the abolishment of the cap of numbers means that it's more viable to recruit from overseas, but also that it's a more streamlined process. We're not having to go through what were monthly allocation rounds in terms of visas. The loss of the resident labour market test, this reduction in skill level, the unrealistic salary thresholds at the indefinite leave to remain point, the fact that those have been stripped away, and significantly the fact that there's sort of no now preferential treatment for nationals of any country, it all does make it a more open system and makes global mobility and the ability to put the best person into role. It makes all of that much more viable and straightforward.
Thank you. Alex, can you clarify what a dependent agent is, please?
Yeah, so this is someone who can bind the company, so who the legislation says habitually exercises authority to bind the company in that country, so conclude contracts, for example. The definition isn't the same depending on the jurisdiction, and it's a bit of a double tax treaty concept, but generally speaking, it is someone who often binds the company by way of concluding contracts, etc.
Okay, thank you. Another one for Alex. What is the NIC position for an employee who works in multiple EU countries?
Right, so if they're working in more than one country, so are they simultaneously or switching between them? If it's an EU country, they will usually be able to continue to pay NIC contributions in the country that they live in, but that's provided that there's a substantial amount of activity pursued there.
Thank you. Just conscious of time, so we've probably got time for one or two more. What is the position for UK nationals living in the UK and having to travel to various EU countries to visit their company's branches and provide training over there? The visits to other countries is an important part of their role, say 50% of it. Would they need to apply for a visa for each country for each visit? They're concerned about the delay in getting a visa, and the trips cannot be planned in months in advance.
Yeah, so this is where we would look to the Brexit deal, and we'd say, okay, well, if those are going to be, if it's going to be 90 days in any 180, then we can cover off our activities under the business visit. So essentially it's visa-free travel for business visitors, and we might possibly want to structure the nature of the role so that it did fit into 90 days in 180, because otherwise you are going to be needing to develop your understanding of the domestic regime in each of the countries that the person would be travelling to.
Thank you. Final question then. What evidence would I expect to see if someone has registered on the EU settlement scheme?
Yeah, I'm glad you asked that because before I was saying, you know, when you see your evidence of leave to remain in whatever format it comes in, and I've mentioned digital status, it's useful to be able to clarify that traditionally we've had what's called beignets, which were stickers in passports or stickers on cards. You would have seen those for European nationals, a blue card folded into 3 with a sticker inside it. Or we've had BRPs, which are biometric residence permits, or cards, which are credit card sized card endorsed with a person's permission. We now will be seeing digital status, and lots of employers, you'll have seen this if people have given you on a voluntary basis evidence of their registration on the EU settlement scheme, but we will be seeing much more use of digital status because the Home Office very much wants to move all immigration status towards digital status. So essentially what that means is that people who've registered onto the settlement scheme will not have an endorsement in their passport, and they will not have anything tangible to show you. So they won't have a card or a sticker or a piece of paper. What they will receive is a letter by email from the Home Office, but that letter itself explicitly says this is not proof of your status. And they may well not have realised that, so they may well give you the letter, and then you have to say, oh, well, if you look at this letter, it gives you a link, and they have to follow that link. That gives them access to their digital immigration portal. And then in there, they click to request a share code, and it's that share code that they need to give to you. And then you go to the employer-facing site. You can't just look at their portal. If they say, okay, well, I'll pull my portal up on my phone and show it to you, that's not sufficient. You have to go to the employer-facing site. You put the share code in, put their date of birth in, and then you will have sight of their portal, and it will give you a good colour picture, facial image of the person, which you can compare to the person that's standing in front of you, and it will confirm what their permission to stay is. So it will say this person has the right to work in the UK. Now, moving forwards, it will also say when that right to work expires, and you from there will be able to save a PDF of that status document, which is just the extract from the portal. You'll be able to download a PDF and save that PDF onto your HR file, and that is your compliant right to work check. And the importance of using the employer-facing portal is that the Home Office are keeping a record of all of the checks that have been made, so they'll be able to sort of audit essentially, and will be able to see that that check was indeed made, whereas if you use the employee side, then there's no record of the check having been made.
Perfect, thank you very much for that. Just conscious of time now, so we'll end the webinar there. If we've not managed to follow up with your question, we'll follow up directly following the presentation. You'll also receive the slides and recording for the webinar later today or Monday. And finally, thank you again to Emma and Alex. And we've got one more webinar left on Monday at 10:30 with intellectual property. So if you are free, please join. There's still plenty of time, and the link will be included in the email that you receive. So thanks very much. Have a lovely weekend, and we'll see you all soon.